So judicial notice is where a court doesn't need proof of something, that they can just without evidence being led in front of them say, okay, this is such a well-known fact that we're just going to accept it. So when it rains, the lawn gets wet, so to speak. We don't need to call somebody to explain that to us. That they can just, but the fact that, and I have to talk about that Ontario Court of Appeal decision, and then I'll just explain that it went further. But so the worst case in my mind is this Ontario Court of Appeal. It's CG versus JH. If anyone wants to look it up on Canley, the citation would be 2023 ONCA 77. And it started in the lower court where we had two parents duking it out over vaccination. The father wanted to get the COVID jab for the kids, and the mother didn't. And the mother, has some internet printouts, maybe of Dr. Malone and whatever, and the father has like the Health Canada printouts. And the lower court judge said, well, it's okay to ask questions, and I'm really not sure, and I'm not granting the father the right to make this decision. So, and it's funny, he was unrepresented, but then in the Ontario Court of Appeal, I think there's 3 lawyers acting for him, if I recall correctly, which is funny, who was financing that. And the Ontario Court of Appeal basically directed the lower courts, no, you take judicial notice. You don't need anyone to lead evidence of the fact that when Health Canada approves a vaccine, that's basically evidence that it's proven to be safe and proven to be effective. So now the danger about that is that, I thought before that the court was supposed to basically be between the state and the citizen, and it doesn't matter if the state takes you to court or you take the state to court. Both sides have to prove their point, not just accept what public health authorities say. But the irony about this Ontario Court of Appeal decision is, so here they're saying, well, the fact that Health Canada approved these vaccines is proof that they're safe and effective, and I'm thinking, they didn't actually look into the law. So they're basically asking lower courts to take judicial notice of a ghost, because our regular drug approval laws, you have to prove safety and efficacy, and then once you've established something safe and you've established it's effective, when these are, safety is kind of a sliding scale and so is effective, then and only then do you do a cost benefit analysis. Do the benefits outweigh the risks? But for these COVID-19 vaccines, that test didn't apply. So I think it was in March of 2020, about a month before Pfizer and Moderna filed their applications, the minister comes out with this interim order exempting COVID-19 vaccines from having to prove safety and efficacy, and gave this other test. And the other test, this may be a direct quote. So the minister has sufficient evidence to support the conclusion, and I'll just stop there. The minister is Health Canada. And if you're supposed to prove something to Health Canada, it should read the minister, so Health Canada has sufficient evidence to conclude. But it doesn't say that. It says Health Canada has sufficient evidence to support the conclusion. So basically there's an argument that the benefits of the new drug outweigh the risk, having regards to the uncertainties concerning the benefits and risks and the urgent public health emergency presented by COVID-19. The word safety isn't mentioned in that test. The word efficacy is not mentioned in this test. So here these vaccines are approved under a test where not only does safety and efficacy not have to be proven, but those words aren't even in the test. We're not here to deconstruct the test, but you actually don't even have to prove the benefits outweigh the risks. You don't have to prove anything really. So I just found it interesting that the Ontario Court of Appeal is directing lower courts to take judicial notice of something that doesn't exist.